Good morning. Thank you so much for joining us for today's Wednesday webinar, where we will be talking about Social Security disability for diabetes. A few things before we get started that I always like to try to remember to say at the beginning of our Wednesday webinars. Number one, if you are joining us on the live, thank you. We will go ahead and drop a link in the chat now, where if you have questions that pop up during the webinar, please hold on to them, write them down, and use this link to schedule a call with us instead of asking questions during the webinar. We don't take live questions on the webinar, and the reason for that is not because we don't want to help, but it's actually because we often need a lot of information from you to be able to give even some semblance of a decent answer that would be helpful to you. And we don't like you to give that information when other people are listening in. So that's the reason for that. Same with if you're watching on the replay. We don't tend to respond to comments on the replay that include detailed questions. And the reason for that, again, is because it's hard for us to give a good answer, either using just limited information that is included in the comments, or we don't want all of that information out there for other people to be able to see for you. So what I will ask on the replay is that link to schedule a call is down below. So do the same thing, kind of keep track of any questions that you may have, and then go ahead and use that link at the end to schedule a call at a time convenient for you. The other thing that I'd like to say at the outset is today's webinar is not meant to be legal advice, but is instead meant to be additional background information for those who have diabetes, who it prevents them from working, and they're considering whether or not an application for Social Security disability benefits may be in their future. So with that, let's go ahead. Here's our roadmap for today. We'll go ahead, we'll talk about some Social Security disability basics, the two different programs, things like that. We'll talk about guidance from the agency. We'll talk about considerations to make. And then finally, how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law. That means that we assist clients with their SSDI and or SSI claims. We can start sometimes at the initial application stage, and we can sometimes go all the way through to the appeals counsel stage. At the time this webinar is being recorded, we do not handle federal appeals. We strictly focus our efforts on the agency level matters for SSDI and SSI claimants. Talking about basics for the two different disability programs. There is SSDI, which is Social Security Disability Insurance, and then there's SSI, which is Supplemental Security Income. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months. Where they differ is SSDI benefits are going to require that you have a sufficient number of work credits. We typically say that you must have worked 5 of the last 10 years for SSDI benefits, but those rules do vary, particularly for individuals who are under the age of 26. SSI, on the other hand, does not have a work history requirement, but it does have income and asset restrictions. With SSI, as I said, there are income restrictions, and we don't talk about those on the webinar because those vary depending on household size. Asset restrictions are pretty black and white. You cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married, and still qualify for SSI benefits. The other thing I want to say while we are on this slide, you do have to be disabled for at least 12 months to qualify for either program. That does not mean that you have to be disabled for 12 months before you can apply for either program. And in fact, I often recommend applying sooner rather than later. And the reason for that is because the worst thing that's going to happen is Social Security is going to say, no, we don't think you're disabled. You just got into a car accident 2 months ago. We think you're going to be fine in 6 months. And, so you apply, you get denied, you file an appeal, and you start to go through the appeals process. It at least gets that ball rolling. With SSI, and sometimes SSDI as well, there's a secondary reason, and that's because SSI benefits are not payable until you apply. So if you become disabled in January of 2023 and you don't apply for SSI benefits until January 2024, that whole year of 2023 is gone for potential SSI eligibility. So I always recommend, if you and your doctors think you're going to be out of work for at least a year, go ahead and apply. If you wind up being able to go back to work during that year, then you just reach out to Social Security and say, hey, I was able to go back to work. I would like to withdraw my application, and there's no harm in that. Okay. SSDI, they can pay benefits up to 12 months before you apply. So sometimes we kind of run into that too. If somebody waits, multiple years before applying for disability benefits, they lose out on some period of their eligibility there. But with SSI, it's even more important that as soon as you realize that you're not going to be able to go back to work, that you consider applying. And you can ask your doctor too, how long do you think this is going to last? Do you think that I will always be unable to work? Do you think that if I go through a course of physical therapy, I may be able to regain my strength and return to work? Do you think that if we try a different medication, it will control the neuropathy and I'd be able to go back to work? So there are things that can be done. Just because you have a diagnosis that immediately makes it difficult to work does not necessarily mean that the whole year is going to, be out. And so it's okay to wait to see what's going to happen. But I just give it as a word of caution that the period of at least 12 months does not mean that you have to wait 12 months to apply. I hope that makes sense. When you initially apply, the very first thing the agency is going to look at for an SSDI application is, do you have the work history that's needed? Have you paid into the system long enough so that you can start pulling your benefits from it? If not, then the agency will deny the SSDI application, and they'll say you do not have a sufficient number of work credits, therefore you do not qualify for SSDI benefits. With SSI, the first thing they're going to look at is your income and assets below the threshold. If your income or your assets exceed the allowable threshold, then the agency will send a denial and say you're not eligible for SSI because your income or assets exceed our threshold. As long as you meet that secondary prong for whichever program you applied for, they'll start this 5-step evaluation process. Number 1, they're going to look, are you engaging in substantial gainful activity? In 2023, that's defined as working 20 hours a week or more, or earning more than $1,470 a month. If you are engaging in substantial gainful activity, the agency will stop the analysis there. They'll say you cannot be disabled under our rules because you're engaging in substantial gainful activity. If you are not engaging in substantial gainful activity, the agency moves to step 2, where they begin to review your medical records. And they are looking through the medical records to see, do you have at least one severe medically determinable impairment? Is there at least one impairment included in those medical records that shows that it's so severe that it would have an impact on your ability to perform typical work activities? If you don't, then the agency is going to stop there and they're going to send a denial letter. If you have at least one severe impairment, the agency will move to step 3, where they look through that medical records and see, do you meet or equal one of their listings? As we'll talk about in a minute, there is no specific listing for diabetes. So this may or may not be relevant in diabetes cases. It depends on what else you have going on. For example, is it diabetic retinopathy, diabetic neuropathy? There are listings for vision loss and neuropathy. So you may be able to look at one of those. If you don't meet or equal listing, that's okay. The agency will then go to step 4, where they create a residual functional capacity for you, which is what they believe you are capable of performing on an ongoing basis, despite the limitations that you may have from your conditions. They use that RFC to see, okay, can an individual with this RFC and the claimant's age, education, and work experience go back to their past relevant work, which is jobs that have been performed in the prior 15 years, long enough to understand how to do them. If you can go back to your past relevant work at step 4, you'll go ahead and get a denial. If you cannot go back to your past work at step 4, the agency goes to step 5 to say, okay, you can't go back to your past relevant work, but are there any jobs that exist in the national economy that an individual with your age, education, and work experience can perform? If there are other jobs that exist in the national economy that are available to such an individual, you'll get a denial. If there are no other jobs, then you can get an approval at step 5. As I mentioned before, diabetes is no longer a listing for SSDI and or SSI benefits, with the exception of 10908, which is a listing for children under the age of 18, And this listing is specifically for children under the age of 6 who are diagnosed with diabetes and require daily insulin. So that's the only listing that exists. Social Security instead considers the impact that diabetes has on an individual's activities of daily living, including the limitations that may be present as a result of diabetic complications, including neuropathy, hypoglycemia, and vision loss. Social Security notes that there are several often seen complications from chronic diabetes, including, as I mentioned before, diabetic retinopathy, diabetic neuropathy, and then cardiovascular disease also tends to pop up often, as does diabetic nephropathy. Okay. At stage 3, which is where the agency is deciding whether or not your severe impairment meets or equals a listing, the agency is going to consider the medical severity. So while diabetes is not a listed impairment for adults, the effects of the diabetes, whether alone or in combination with other impairments, may meet or medically equal the criteria of a listing in an affected body system. So below are some of the examples. As I mentioned, there's diabetic retinopathy is listed second, and that would be reviewed under one of the listings in the special senses in speech, which are the chapter 2, basically. Diabetic neuropathy would be looked at under the neurological listings, which is chapter 11. We talked about hypertension, cardiac arrhythmias, heart failure goes into the cardiovascular system listings. Diabetic nephropathy would be looked at under chapter 6. Slow healing, bacterial and fungal infections are common in diabetics, and those would be evaluated under the skin disorders. Amputations would be reviewed under the musculoskeletal system listings. So as you can see, there are a lot of complications that can happen with a diabetes diagnosis that would probably not have happened but for that diagnosis, but it's not going to be the diagnosis that's going to be disabling. It's going to be the side effect. Okay, I hope that makes a little bit of sense. As always, medical records are going to be critical. There's also a ruling that the agency put out in 2014, Social Security Ruling 14-2P, and that can be a helpful resource to diabetics for understanding how the agency reviews and considers claims that involve diabetes. I don't believe, I didn't include it here, but if you Google Social Security SSR 14-2P, it'll pop up, and that way you can go through and read that and kind of have a more fuller understanding of how the agency is going to look at claims that involve diabetes. And here we are at the end. How can an attorney help you? This is not an exhaustive list. This is just some of the stuff that we tend to do most commonly. We can provide guidance on what correspondence from Social Security actually means. If you are already a client of ours and we get a denial, or you reach out to us shortly after receiving the denial and we have a sufficient time to file the appeal, we can file necessary appeals. We review your medical records in your case file, and we can discuss what additional records may be helpful in your case. We review your documents for accuracy and completeness, and we can discuss with you what the agency may be looking for in their requested forms. So these are the forms that the agency will often send out, like an adult function report or a supplemental pain questionnaire, supplemental cardiac questionnaire, things like that. Where we can kind of give guidance on what the agency is looking for in these forms, but we can't fill them out for you. We can't feed answers to you. And the reason for that is I call these forms kind of testimony without having to go before a judge. And it can be helpful for you to fill these forms out so that way the agency can better understand what you're going through, where you're coming from, and what you deal with on a day-to-day basis. These are in addition to the medical records that they have, and they can add additional color and personal touch to your claim. We work with you and the agency to provide relevant updates to and from you and the agency back and forth throughout the claim. If you have to go to a hearing before an administrative law judge, we do prepare you for that hearing, and we question you and any witnesses during that hearing. When I say we question witnesses, I don't typically mean family members, friends, and prior coworkers, but instead it tends to be the agent or the witnesses that the agency brings, such as a vocational witness, a medical witness, things like that. Your personal witness statements, if you're a client of ours, we have a different way that we try to get that evidence in. And the reason is because the time allotted for these hearings is so small that many judges do not fully appreciate and understand and listen to live witness testimony in the hearings. And so we have alternative ways that we can sometimes get that testimony in. All right, here's our contact information. If you do have any questions, please do feel free to reach out to us. We are always happy to help in any way that we can. If for some reason, as I said before, we cannot help, we do try to point you in the direction of someone who may be able to. So please feel free to give us a call, send us an email. On the live, we'll go ahead and drop that link in the chat to schedule a call again. And that link to schedule a call will be down below on the replay. Thank you so much for joining us today. Have a wonderful day.